All right, we're going to get started. As I said, my name is Mike Whalen. I'm the Chief Community Officer here at Law Insider. My job, in brief, is to set up trainings like this of all different types to try to help you all be better at your job of drafting contracts faster. So we decided to invite our friends from Praktio to come and talk about this subject that we've gotten a lot of requests for, which is about drafting indemnity. As we do this, I've just got a couple of housekeeping items to tell you. One, we have open both the chat and the Q&A function. And we do that for a reason. It's really hard to keep track of chat with a group this large. So if you have questions that, specifically if there's substantive questions that you want answers to, go ahead and drop them in the Q&A. Not only is that valuable for this conversation with Michael, we'll be able to address some of those questions, but also it's valuable into the future. I had an idea even to write a blog post following up on some of the questions that were in the list. So we could even do something like that where we're following up later. So please ask questions in the Q&A, specifically if there are substantive legal questions that you want to ask about. Use the chat, though, to talk to each other. If you want to talk about, in my jurisdiction, this works. Have you guys ever seen this? What tool are you using for that? Those kinds of conversations are really great in the chat. Josh will also be here, and Michelle sharing links to things that are relevant. So with all of that, I want to turn time over to my friend Michael Bloom. Michael, you are with Praktio. I don't do long introductions. I'm just going to say I'm pretty sure you went to school here. Is that right? You went to school here in Chicago?
I taught at University of Chicago Law School, but I went to school, Michigan for undergrad, Yale for law school.
Awesome. And now you run this company, Praktio, where you are doing practical trainings for different size law firms and corporations that you're teaching these legal departments. So you are well and truly qualified. We'll have a long bio in the link over there. But I want to turn the time over to Michael. Again, I may interrupt every once in a while. If there's a question in the Q&A that is timely and relevant, I'll jump in. But otherwise, Michael, this is your show. I'm going to turn it over to you.
Awesome. Thanks so much, Mike. And thanks to everyone at Law Insider. Really excited to be putting on this webinar and hope for it to be as conversational as possible. So just to echo points that have already been made, please ask questions as we go. Here is the agenda for the next hour or so. We'll spend the first half talking about the elements of indemnity provisions, the common checklist questions to consider whenever you're drafting, reviewing, negotiating these things. And then we'll spend the back half or so working through interactive exercises. This is a hallmark of my teaching style back when I was a clinical professor at Chicago and more recently at Michigan Law School. And it's a hallmark of Praktio's approach more generally. So we believe, and it's been proven by science, that you learn not by just listening to folks like me click through slides, but through actually practicing and getting feedback. So we will spend a good chunk of time doing that, and I'll speak more to that when we get there. But again, and questions is number 3 on the list, but please, again, ask questions as we go. We have a varied audience of different levels of experience and skill set. So you calibrate me on the level of detail that you want me to get into, more or less, through your questions, and we will do our best to address and to calibrate as we go. So that's the plan. Let's get into it. The elements of indemnity provisions. So I often quip that I can tell what someone's sort of formative practice area was or is by asking them what they think indemnity means. The M&A lawyers will answer that question one way, but they'll really answer it with how they see it used in M&A agreements. And the in-house lawyers and the technology transactions lawyers and the folks dealing with agreements like SaaS agreements and services agreements will answer that question a different way, but also by telling me how indemnity is used in those agreements. We'll get into all that in a little bit more detail here today, but my point at this moment is to say indemnity is more basic than all that. It is specifically at its core just a particular kind of covenant. A covenant, as a reminder, is a particular contract provision that is a promise to do or not to do something. It's about future behavior of a party. And indemnity is a subspecies of a covenant. More specifically, it's an obligation to pay for stuff. And what that stuff is, we will tease out in several slides to come here. But At its most basic, that's all it is. And oftentimes it also comes with an obligation to defend against third-party claims if it's drafted accordingly, and we'll get into all that too. But so this is my opening slide for a reason. I find that lawyers are often talking past each other, especially if someone comes from a big law practice and ends up negotiating a technology agreement or what have you, vice versa, where they're coming at it with a different set of experiences and they're confusing their experiences with all the different ways indemnity could be used if the parties agree to it. So at its most basic, just a particular kind of covenant. More specifically, I'm going to get into some key questions. So starting with who and also sort of whom. So who is providing the indemnity? Who is undertaking the obligation? Might call these folks the indemnitor or the indemnifying party. That almost certainly is going to be a party to the contract itself. And then we have on the other side who is receiving the indemnification, who is receiving the benefit of it. Might call these folks indemnities or indemnified parties. This will likely include a direct party to the contract, but it also can include other folks too. Folks like affiliates relative to the party to the contract, their directors and officers, maybe their employees, and maybe going so broad as to cover contractors and agents too. Whoever's listed here, again, these do not have to be parties to the contract. We might call these folks third-party beneficiaries. So just kind of going back to Contracts 101, two parties to a contract can agree by contract to bestow benefits on a stranger to the contract. And here's an example of where that comes up in indemnification provisions. On the other hand, just to round out the lesson here, two parties to a contract cannot bind a stranger to the contract, right? You need their authority or they need to agree to be bound by certain obligations. So on the indemnifying side, that's going to be a party to the contract. On the indemnified side could include these additional third-party beneficiaries. And again, ask questions as we go. We'll try to scan these, and Mike's going to help me pull out the really good ones and interrupt as we go here. Then getting into the what. Three basic pieces here. The types of losses covered, jump into the bottom, the types of events or risks covered, and then in the middle, the relationship between the two. So the types of losses, these can be things like damages awarded by a court, liabilities, obligations that are owed, and expenses, fees that are incurred by a party. And these often are drafted to include attorney's fees as an example of that. And then jumping down to covered events, this is usually what we use to describe the indemnity. Oh, it's an IP infringement indemnity, right? So what is actually being covered? What are the sources of risk that we're looking to shift as between the parties from the indemnified party to the indemnifying party? Can see a whole slew of things depending on the type of agreement here, depending on the particular risks at issue, but kind of classic suspects include things like breach of reps and warranties, breach of the contract in general, breach of certain provisions in the contract, like an IP infringement warranty. Maybe separately specifying, maybe there's not an IP infringement warranty, but we want to include IP infringement as a covered event on its own here. Could more broadly be any acts or omissions of a party that causes these damages or bears a relationship to. And on that last point, what is the relationship between those losses on the top and those covered events on the bottom? The main lesson on this point is it can take either of two flavors. It can be causal or non-causal. Examples of non-causal words of relation or nexus phrases are things like relating to, in connection with, these prepositional phrases that are broad in nature and are not speaking to causality. Versus more narrowly, we can tighten up an indemnity and narrow its scope by using causal language like resulting from, caused by, due to, right? These are ways to clamp down on the indemnity and limit its coverage through these particular prepositional phrases. So something to look out for. Are you looking to widen the coverage using non-causal language or narrow the coverage using causal language? getting into some more nuances under the what question. And this is one particular place where I can really tell if someone grew up as an M&A lawyer or grew up as a commercial transactions lawyer. Indemnity can be drafted, can be agreed to be only about third-party claims. One stranger to the contract sues the indemnified party and they seek to be protected by the indemnifying party. Or could be also about any claims that's between the parties, say breach of the contract itself, for example, regardless of whether some third party is in the mix. There's not a right or a wrong answer here. Some of you with experience in these areas might feel passionate about this, but indemnity can be drafted and agreed in either way. It's conventional in certain agreements to take one approach and in other agreements to take others. Ultimately, it should just reflect how the parties agree to shift risk as between them. And we will look at all of these issues in more detail, including in the exercises in the back half today. Another what question that gets into when is, at what point must the indemnitor step in to perform its indemnity obligations? At what point in sort of the spectrum of events that could occur? Is it as early as when a party receives a cease and desist letter accusing them of something? Or is it as late as when a court of competent jurisdiction fully appealed, fully adjudicated, awards some final damages, and that's when the indemnifying party has to step in, or any events on the timeline in between? So thinking about when the indemnitor either has to step in or has an option to step in and maybe take control, for example, of litigation. As we're carving up the indemnity into these different elements and thinking about these different puzzle pieces, we have to also zoom out and think about how they play together. We need to create a coherent story here. So, for example, it wouldn't make sense to have a defense obligation that kicks in after finally awarded damages after litigation, right? The defense is over. That's not coherent. So we have to make sure that all of these pieces, of course, snap together in a way that ultimately makes sense. And then thinking on the other side of the equation here, the party receiving the benefit of the indemnification, what responsibilities do they have? One could be, and commonly you see, some obligation to provide notice to the indemnitor. So they're able to potentially step in, maybe take control, maybe mitigate through certain things, stop doing the thing that's causing whatever the subject matter of the risk is. Often we'll see some obligation for the indemnified party to cooperate and assist with the indemnitor's defense against a third-party claim, for example. And related to that, these questions of control. Who gets to decide whether to settle? Who gets to control the defense strategy? On the indemnifying party's side, they're likely to want that, especially if they're ultimately going to be on the hook for the final bill. They'll want some say on how the defense is administered. In this particular place, but also more generally, this is a great question to always ask yourself throughout a contract. So here asking, or what? So what happens when the indemnity does not do what they're supposed to do? So for example, they don't provide the notice that they're supposed to provide as part of their side of the deal around an indemnification. Is the consequence that the indemnitor is just totally relieved of its indemnity obligations? I think of this as a binary conditional relationship, a light switch that flips the indemnity into the off position. Is it more proportional? So the indemnitor is relieved, but only for the portion of additional losses caused by the indemnity's failure to do what they were supposed to do. So it's still conditional, but instead of a on and off light switch, it's a dimmer switch, right? It's just sliding to the position, allocating responsibility to the indemnity for the part that they caused due to their failure to do what they were supposed to do. Or is it just a covenant? And if the indemnity doesn't do what they're supposed to do, they breached, and indemnitor, have fun, sue me for it, whatever you can prove damages caused as a result, you can potentially recover or offset, right? So something to pay attention to here. is the or what specified, and then how is it specified? How would you want it to be specified? You know, the indemnifying party would love for it to be that on off, you didn't do what you're supposed to do, foot foul, I don't have to do anything. The indemnified party might take some issue with that approach. Understood, I should have gave you notice yesterday, but either harmless error or only cause some minor additional damage. So you're not responsible for that, but I still expect you to step in and do what you were supposed to do had I given you, say, the notice when I was supposed to. So you can certainly see this from either side's perspective. See, there's lots of questions. Mike, any ones you want to call out, or I can scan these too?
Yeah, I'm looking to, honestly, some of them are for me, because they're sort of basic entry questions.
Yes.
One, I'm trying to think about, where does the conversation about indemnification fall in the deal story? Meaning, one question that we got was, Meredith asked, is it always a warning sign when the other party will not agree to indemnification? And the reason that's tying to the moment in the deal story to me is, if that's always a warning sign, then should we have that conversation very early? Is that something that's going to break a deal later? And then also we got a question about what's the difference between an assumption of risk, a party being liable for all losses, and indemnity. So those are a couple of sort of orienting questions, maybe. So taking a step back, but if you could give us that context.
Yeah, so thanks for that. So as I suspect most folks in the room will predict, I have the lawyer's answer to that first question, that it certainly, I'm not going to say yes to always, and it definitely depends. And what does it depend on? So certainly part of it's going to be the conventions of the deal, right? So if I'm buying technology from you, and part of the expectation is if I get sued for IP infringement because I'm using your technology, that look, I'm buying your technology, I'm not buying the lawsuit. I would expect the supplier to stand behind what they've done. That would probably be a red flag to me as a buyer or a licensee of software or other technology, if the provider is not willing to stand behind in this case, the sort of IP integrity of what I'm purchasing, right? So that's just an example. There certainly could be other types of deals where either because of the price, because of the risk that is implicit or explicit in how we're agreeing to do the deal, and shift risk between us, that, hey, we're buying the $10 toaster here. We expect that not everything's going to go right, and that's kind of what we're paying for, and that's fine, right? So it depends on the party's expectations, and that's certainly going to be informed by the conventions of the type of deal, the type of industry, what you normally would see. And against that backdrop, if you're seeing something radically departing, then yeah, that's going to be a red flag. But I think always is going to be a bit strong there. Assumption of risk, I mean, we hear that like in tort law. I don't see that language a ton with indemnification or in contracts more generally. But kind of tying into the prior point, I'm not sure if this is where the question is going, and feel free to follow up whoever asked it. What is the expected deal between the parties? How are they expecting to allocate risk? If you can get aligned on that, we can make the indemnity and the reps and warranties and all these provisions say and do, exactly that. I find lawyers often zoom into the commas and the particulars and like to show off what they know or don't, or the other side doesn't about the particular provision. They skip ahead to the wordsmithing of it all, and they don't go through the process of getting aligned on the concept, to the principle. How are we trying to price this deal? How is risk supposed to be allocated between the parties? All right, and once you agree at that level, the indemnity is actually relatively easy to draft to capture that risk allocation. All right, I'm going to keep going, and folks keep asking questions, and at a minimum, I think we can pause at certain times and take stock of what's been asked and see if we can knock out a few of these. Okay, and so then thinking about, and I did see some questions on this, so hopefully this is responsive. What might limit the indemnity in the contract that contains the indemnity? One category are going to be your limitations of liability, in particular your caps. You can have a cap that is built into the indemnity section. You often see this in, say, those M&A agreements, or maybe you have a more general liability cap, say in those commercial agreements. If you have a general cap that applies broadly to liability related to the agreement, make sure that you are explicit about whether it applies or doesn't apply to the indemnification provision. Silence here is a recipe for dispute, and I have seen court cases that have gone either way on the facts of that case. So if it's silent, if you have an indemnity and you have a liability cap kind of sitting side by side in separate provisions, and there's not explicit language explaining that, hey, the cap caps that indemnity, or the indemnity operates independent of that cap, you're kind of rolling the dice on how that will ultimately get resolved were it to find its way to a courtroom. And usually we can't talk about caps without talking about baskets. They're pretty different devices. They're materiality thresholds. So saying, hey, until the claim exceeds X dollars, the basket amount, the indemnifying party in this context does not have the obligation to indemnify at all. So don't bother me with sort of those trifling matters, but once it crosses that dollar amount, that basket, all right, at that point, it is ripe and indemnifiable under the provision if we have a basket provision in the contract. Exclusion, so thinking about anything to be carved out from the scope of the indemnity. One classic example here is something called the express negligence rule. What this says is if the contract is silent on the matter, as a matter of interpretation, we're going to presume the parties did not intend for the indemnifying party to indemnify the indemnified party for the indemnified party's own negligence. So put more simply, we expect folks to be responsible for their own bad acts, for their own negligence. And if the parties intend to allocate the risk different from that, they need to say so explicitly. Otherwise, we're going to assume they meant to do this in a, quote, more normal way. I would be explicit either way. If you mean to exclude or include the indemnified party's own negligence, I would include language that makes that clear. One theme throughout all of this is being a good preventative, proactive transactional lawyer. We don't want to have to make these arguments in our courtroom. Ideally, the contract is nice, clear, buttoned up in a way where these answers are obvious on the face of the document. But you certainly could exclude other things from the scope of the indemnity. Another point here is when you have mutual indemnity. So, two kind of dueling indemnity provisions with either side either being on the indemnifying party or indemnified party side of each one. Being careful to avoid overlap in the coverage. We don't want to create this infinite loop where they can keep seeking indemnity from each other for the same underlying covered event. And so one way to address that is to exclude certain things from one that's covered by the other, so it's clear that only one indemnification provision is applicable to the particular risk event that might occur. And the last bit here to note is time, claims periods. Do we want to limit by when a claim must be brought for it to be covered by the indemnity? That's another way to limit the scope and coverage of the indemnification provision.
Michael, if I can ask a quick question on that, and this might come up in your red flags later, but Jeffrey asked the smart question, can you discuss the relationship between indemnity provisions and limitation of liability clauses, which can sometimes subtly limit indemnity? So when you're doing this and you're looking for the limits, talk about looking elsewhere for limits outside of this clause.
Yep. We will talk about this more later too, which I'll speak to it now and kind of look out for this in the exercises that follow. But again, you can, in some agreements, say those M&A documents, those big complex ones, you're likely to have, your article on indemnification going over many, many pages, and your caps and baskets and all these limiting devices are going to be baked into the indemnity section. And then in those more commercial agreements, say your SaaS agreements or your master services agreements, et cetera, it's much more common for limitations of liability to be in a separate section, distinct and apart from your indemnity. And that's where it can be unclear if the parties don't draft clearly whether the limitation of liability applies to the indemnity to cap it or what have you, or if the indemnity is its own independent beast that operates outside of that cap. And put your antennas up. That's going to, a little hint for later, that let's say might come up in some of the exercises to follow. All right, so let's tick through some of these differing views that we've covered in one place here. So again, one question ought to be, is the indemnity only about third-party claims? Similar, does it include an obligation to defend against those third-party claims? Is indemnity the exclusive remedy for the parties? Is it the exclusive mechanism for redress as between the parties to the contract? And hey, whether an indemnity covers third-party claims, inter-party claims, or both, does not go to the definition of indemnity. It depends on how the clause is drafted. Whether an indemnity includes an obligation to defend depends on how the clause is drafted. And you might see where this is going. Whether an indemnity provides the exclusive remedy between the parties, you guessed it, depends on how the clause is drafted. So all of these things are ultimately choices that we make. These are different levers or switches we can control on the provision. Again, convention might dictate the approach we take, but don't confuse this with what indemnity essentially is or has to be. And just to kind of put all that on one screen, again, typically in commercial agreements, indemnity is drafted to only be about third-party claims. It might or might not include an obligation to defend. It probably does. And it is usually not going to be the exclusive remedy, at least not broadly speaking. Versus on the complex agreement side, like those M&A documents, typically this will be about both third-party claims and inter-party claims. Typically, it will include an obligation to defend along with a very carefully articulated set of procedures and requirements. And because it is so broad, because it is covering both claims directly between the parties, breach of this contract, and those third-party claims, it is meant to be, and drafted this way, the sole mechanism for redress between the parties. So all liability roads go through the indemnity section in these types of agreements, and then go through that to figure out how to handle the situation, with important limited exceptions for things like fraud. And that's because fraud doesn't care about your contract. The colorful language you find in judicial opinions here that always sticks with me when I'm thinking about this is that fraud vitiates everything it touches. So think of fraud as a flame and your contract as the kindling, and the fraud doesn't care, right? So you cannot limit liability effectively for intentional fraud as a matter of public policy. It just won't be enforceable. And similarly, if our indemnity provisions are drafted to try to limit the potential remedy for fraud, they will not be effective, at least in U.S. jurisdictions. And this is why you often do see called out explicitly exceptions for fraud in the agreement. You don't have to, it doesn't matter, the court won't care, but it's a way to make explicit what the how these provisions operate. Okay, I am going to be quiet for at least a minute, and I'm going to ask you all to just look at this example and try to identify in the wild all these different elements that we just ticked through. And then next screen, I will debrief with you all. But no technical difficulties here. You are not going to hear anything for at least a minute or so. And I will give you a chance to work on this.
And feel free to share your thoughts, what you all are seeing in this section in the chat, so that you guys can ping it around a little bit. So if you see some of these elements, call them out in the chat.
All right, I'm getting enchanted with all the questions. I'll try to get through some of these, but time flies by reading questions about indemnity. On the basics here, just ticking off where some of these things that we've discussed are present. We see here a duty to defend. We see those third-party beneficiaries and its affiliates and their respective officers, etc. We see that it's called out here that claims, whether alleged, adjudicated, or otherwise. So at the allegation stage, the claims are indemnifiable here. And we see also called out explicitly that it includes both third-party claims and claims between the parties. We see a broad non-causal nexus phrase in related to. We could decide to make that more narrow and change it to, caused by, for example, but that's what we see here. And then it's not underlined because it would just basically underline the whole paragraph here, but the A, B, C, D, these are our covered events, the sort of subject matter of the indemnity. I saw a question about indemnify versus hold harmless, and I know some folks get exercised about this. I have not yet, and feel free to chime in with additional citations or examples here. I'm yet to see a case where this distinction is actually interesting. Folks like to get medieval and talk about swords and shields, and it's, oh, this one's more this and this one's more that. At the end of the day, I have not found a meaningful difference where in both cases it's about the party undertaking this obligation to indemnify or hold harmless, paying for whatever they are specifying they will pay for. So again, happy to hear other perspectives on that, but practically speaking, I have yet to encounter a meaningful distinction between those two. Let's see if there's any other quick hitting questions that I can knock out. I see some mention about a nonprofit and undertaking indemnity sort of being a big task. On the flip side of that, this is true of all contract provisions, but certainly if you're looking to receive an indemnity, it's always a good idea to zoom out from the page, do your diligence on the other party, and think practically about how deep those pockets are, right? So an amazing ironclad, broad, comprehensive indemnity from a penniless indemnitor is not that valuable. Right. And so consider that, maybe that impacts whether you do the deal with them in the first place or other provisions under the contract, or I'm seeing mentions of insurance, whether to get insurance to kind of shift that risk to a third party, but that should be part of that broader calculus in general. I think, I mentioned us lawyers tend to kind of fall prey to the trap of the minutia before we get aligned on the concept. Here's another one. We can fall in love with our beautiful language and fail to appreciate the actual practical value of it in the form of who's actually standing behind it and how well resourced they are. So I think that is a through line through at least a few of the questions. Keep asking them. There are a lot in here. We will answer as many as we can as we go. But so that's taking through the kind of basic elements of indemnity provisions. In a moment, we're going to get into the exercise portion. But before we do that, it is poll time. So I think in a moment, you will all see a poll. I'll give you about 30 seconds to answer a couple questions for us. Should be up on your screen now. Please take a moment to do that. And while you're doing that, I will start to tee up what we're going to do next, which is similar to what we just did. We're going to put excerpts on the screen, and now I'm going to ask you to try to look for what I'm calling traps or pitfalls, kind of mistakes, opportunities for misalignment, opportunities for improving the language from either party's perspective. Again, for each of these, I will mute for a minute or two. Again, no technical difficulties, just giving you a chance to work through it on your own. And then I will debrief as we go. To Mike's point, feel free to throw your thoughts into the chat or ask any questions, and we'll do our best to be as responsive as we can be. Looks like we got a pretty high poll response rate, so I am going to keep on keeping on here. So again, I'm going to mute, take a look at this section, tell us what you think, and then I will debrief this in about a minute or so. All right, let's get into this one. All sorts of issues to call out. The one I want to focus our attention on is the or what question. What if the indemnity does not do what they are supposed to do under this procedures section? I don't know. It doesn't say. So we could have it say. With something like this, for example, I'm not saying this is good, but the failure to notify as promptly as practicable, and I see some comments on this promptly approach, shall not relieve the indemnifying party of its indemnity obligations, except to the extent that such failure shall have actually immaterially prejudiced the indemnifying party. Very classic language that we see. There is an issue in that language that was surprising to me. Maybe it'll be surprising to you, I don't know. But I'm going to give you another 30 seconds to chew on that, and then I will tell you what I mean by that comment. So what I want to call your attention to the extent that, in this context, is this speaking to that proportional dimmer switch that, hey, only those additional damages caused by the failure are what are relieved if the indemnified party doesn't give that notice? Or does this mean if? Is this the on-off switch approach where it's turning off the indemnity? I would have thought it's the proportional approach, the dimmer switch, and I suspect many of you think that too. Interestingly, in this particular case, the court said, hey, at least at the summary judgment stage, we don't know. It's ambiguous. I could imagine it being reasonably interpretable to me either, which was surprising to me. Maybe that's surprising to you. As good preventative lawyers, we want to avoid being in these situations in the first place. So what if we just use different language and more explicitly spoke to what we meant? For example, except for the portion of any damages caused by such failure, or maybe like a different formulation. But the point here is beware to the extent that, because at least in a particular case here, it was found to be ambiguous, and there's an opportunity here for us to be a bit more clear. Before I move on to the next one, I do want to tick through a couple more questions. I see a comment about subject to the provisions of section XX. Always thought this was rather strange. What is the point of this? If the very essence of an indemnity is its absolute nature, what could other sections provide for that would have relevance? Okay, so a couple things I want to poke at there. Indemnity is not absolute in its nature. Again, this is all about how we draft it. We can draft indemnity to be subject to a limitation of liability cap. There's nothing inherently right or wrong about that. It's just what the parties ultimately agreed to. We should be clear about what the intended interaction is between those two provisions, but that's what the subject to language would mean. And you might be, see if I can tick back. You might be referencing in our example, the subject to language here, right? So that's what this could be referring to, these other limiting type provisions that we've spoken to earlier, like caps, baskets, required procedures, claims periods. These are all things that limit the indemnity. And then I see a lot of questions about, and again, I know the folks asking this are almost certainly kind of in-house type counsel or folks that deal with a lot of commercial agreements, maybe technology transactions. What's the point of indemnity when we have breach of contract for claims just between the parties? I hear you. One answer is there's just different conventions and folks are more comfortable with either approach of indemnity. And it's almost certainly because it's what they grew up with. It's what they were more used to in their formative years. With indemnity, it's more conventional to call out things like attorney's fees, for example, and to cover additional things that wouldn't necessarily be covered in the US for kind of plain vanilla breach of contract. Now, of course, you might be thinking, oh, we can do that with other provisions too. Absolutely. You can, without an indemnity, use other provisions to absolutely get to the same place as an indemnity gets you. There's not one way to get to a desired result with contract provisions. There are potentially alternative routes to get there. But there are ways that are going to feel more familiar to certain folks in certain industries and certain types of contracts. So Indemnity is not the only way to get there, but it is one way that is common in certain types of contracts to use it to include coverage for breach of contract. Maybe we want broader sets of damages. Maybe we don't want to have to prove causality. We can use those broader related to phrasing, right? So there's different facets, but again, you can accomplish that in other ways too. I'm not here to say indemnity is the only way, but it is certainly a way that you all, I'm sure, encounter quite a bit. Let's get going into the next one. I will mute and I will look at some more questions in the meantime.
I'm looking at the chat to see what y'all's feeling is on this section. Tell us what you're seeing.
Here's what was surprising for me here. The underlying question. So this is from an M&A context. So we have reps and warranties contained in this agreement shall not survive the closing, except for these extra special ones, these defined fundamental reps, which shall survive indefinitely. So one question I have, and this sort of echoes sort of claims-based versus occurrence-based insurance. If the breach of a rep and warranty occurred pre-closing, while it was in survival mode, but the claim for it is not brought until after closing, may that claim be brought, or is it barred by this language? Well, it turned out when this question was in front of the courts in Delaware, they said, nope, you cannot bring a claim post-closing for a breach of rep and warranty that occurred pre-closing if those reps and warranties did not survive the closing. So they have to be in survival mode for a claim to be bringable. So in effect, survival here is creating a claims period. So if that's not what you intend, you can draft accordingly to make this do what you want it to do. So if we wanted to establish the sort of tail claims period, we can include language that explicitly does that, right? Because ultimately it's just a task in trying to figure out what the parties intended. And so we can add something that says, hey, never mind what we just said, if that breach occurred pre-closing while it was in survival mode, any claim that's brought, in this example, 6 months after the termination or expiration or after the closing may be brought, and anything after that will be barred. And even if you didn't want to take this approach, if you like how Delaware came out on this question, or for your particular deal, you wanted these reps and warranties that did not survive closing to be something you can wash your hands of and not have to look over your shoulder and worry about claims coming up post-closing, I would also go ahead and add a sentence that says that too. Let's just be explicit about what the parties' expectations are here. I saw some other questions. Again, lots of questions and some great conversation in the chat. I wish I could get to everything. John asks, when an indemnity clause has third-party beneficiaries, so those additional folks getting the benefit of the indemnity, do you recommend carving out indemnity from the no third-party beneficiaries provision? I love this question because we too often ignore all those, quote, boilerplate provisions in the back. And as a result, we often create internal contradiction in our contracts. Yes, we should make these provisions speak to each other. Don't say there are no third-party beneficiaries, period, in a contract that has third-party beneficiaries. So you could, one approach to John's suggestion is you could, in that no third-party beneficiaries clause, say, except for the buyer indemnities in section whatever, or except as otherwise provided in section wherever the indemnification section is. But yes, there's lots of other examples of this, but I love it as a broader point. we do have to have awareness of what these sort of general miscellaneous rules are in the back of the contract, so we're not creating this internal sort of spaghetti code mess of provisions that are fighting each other in the same document. I'm going to keep going here, give you another minute or so to work through this one while I pick out a couple more questions to answer.
All right, let's see in the chat. I should see that busier. What do you guys think? What are you seeing in here? Ben, I like your response. There's too much to even list on here.
Hilarious. All right, let's get into, so lots of things in all of these examples, always at least one that I want to highlight because there's a particular lesson or surprise at issue. The one question I want, and I see some questions more generally on this topic, is I don't know if this indemnity is only about third-party claims, which I gather from the chat that many of you are accustomed to taking that approach. If it includes claims directly between the parties, not involving a third-party claim, or both. It is ambiguous on its face, and when we draft this way, we're leaving it up to a potential dispute and then ultimately potentially a court to try to discern what the parties intend. For example, in this particular case, that was found to be only about third-party claims, where I believe the argument was trying to get attorney's fees included because the indemnification provision included reasonable counsel fees. I think this is actually the exact language from this case. And so the party receiving the indemnity wanted to kind of shoehorn their claim into it so they could also recover attorney's fees. And in this case, the court said, nope, this is just going to be about third-party claims. But there are cases where it came out the other way too. So however strongly you feel about what indemnity ought to be or how it ought to be used, if you mean it to only be about third-party claims, go ahead and say so. So there's not room for argument later. Even if you win the case, you lost because you had to deal with a litigation. So examples of different ways we could address this. You know, this is the broad approach that you see more in M&A agreements. And here's something that's more like what you might see in a commercial agreement for services, goods, software, etc. All right, this will give me an opportunity to answer a number of other questions in the chat, but for now I will mute. Go ahead and throw your thoughts in the chat. I'll give you a couple minutes to work through this guy. All right, let's take a look here. What I want to call out is something that's echoed throughout today's session, the interaction between an indemnification provision and in this example, a separate limitation of liability. And the question that I have is whether the indemnity is limited by the limitation of liability here, and I don't know the answer to that question. Silence is a recipe for litigation, giving you a particular case site, but the main takeaway here is if it's not made clear on the face of the document and it does find its way into a courtroom, the judge is going to try to have to discern what the party's intent was. And there are different cases where that has resulted in different conclusions, right? So if you have an intention, go ahead and make that clear in the contract. Maybe we're of the view, or at least in this deal, we've agreed that indemnity ought to be that absolute right that somebody else described it as, and should stand apart, independent from the limitation of liability. Limitation of liability, that's for the other stuff, but indemnity, that's where we're carving out exactly what we will be shifting risk to the supplier on, and so it should not be kept. If that's the view, say so, and add a carve out like we see an example of with the added language here at the top of section 13. And it gives me a chance to at least partially answer another question on consequential damages, which I would need another hour to fully handle. But if we wanted to be clear that the waiver of consequential damages does not apply to the indemnity, by putting this exception at the top and having it distribute down to both the cap and the exclusion of damages, we exclude the indemnity from both. And whenever we have carve-outs anywhere, and in particular with limitations of liability, and I think this is also getting at a few of the questions I saw, we absolutely need to take a fine-tooth comb and closely review the sections that are carved out. So what is the scope of that indemnity? We have capital C claims here. We should look at how it's defined. It doesn't include those third-party claims. Does it include breach of this contract? If it's so broad that it includes breach of this contract, we now potentially have an exception that swallows the rule. Now, if all claims, including for breach, can be brought through the indemnity, and the indemnity is carved out from the cap and the exclusion in section 13, what work is that limitation of liability doing at all? So the thinking about the interplay of these two sections and what are we trying to accomplish? Are we really trying to be cute and nullify the value of that limitation of liability? Or do we mean for the indemnity to be maybe more narrow than it's currently drafted and have it be uncapped only with respect to those particular covered items? Okay, keep going. I'll look at more questions and I'll give you a minute to take a look at this one and keep chatting in the chat. I love to see it. All right, let's keep ticking along here. So this was an opportunity to catch that issue around our dueling indemnities or mutual indemnity. Whenever you see mutual indemnity, among other concerns and considerations here, thinking about the coverage of each and is there any potential overlap? If there is potential overlap, then we create this infinite loop where we can keep seeking indemnity theoretically from each other for the end of time or until the clock runs out on this contract. So figuring out what we intend is always the first question. And then let's get this contract drafted so that there is not this overlap. And so maybe we add an exception in 12.1 to sort of carve out the part that's overlapping between 12.1 and 12.2. Okay, that is the main thing I wanted to cover there. Still seeing a lot of consternation about this idea that you might have indemnity cover inter-party claims and why would you might want that. And I suspect many of you are on the supplier side, and I'm so annoyed of these buyers that keep asking for the broad indemnity, and I get it. The additional benefits could be, again, that you could have, let's go back to our elements slide. Bear with me. So, whoop, overshot. Okay, so it could be that, hey, it's a way to get this additional protection for those, quote, additional insureds. I mean that by analogy, under this contract, those third-party beneficiaries. You don't normally get that for ordinary breach of contract. Maybe that's a thing here. Maybe we have this great, well-articulated, negotiated set of procedures in our indemnification section. We want to run everything through that. And we want this singular sort of single source of truth for how all dispute, all liability will be handled. And we want to run everything through the indemnity. Now, again, that is not the conventional approach in commercial agreements. So if you're not used to seeing that, that's probably why I am not advocating for it. But just broadening your aperture, you will see that in other types of contracts like M&A agreements, syndicated loan agreements, these sort of more complex agreements. That's the approach they take. None of it's right or wrong. You can kind of get to these same endpoints in different ways. Just wanting, we have a broad audience and there's a broad set of approaches to indemnity out there in the world. Okay, we are getting close to the end of the hour, and we've saved, in my view, the best for last, which is a very special offer we are making for folks attending this webinar. So
yeah, Michael, I have to say something that I've noticed. I've noticed two things while listening to this conversation. One is there are a lot of questions in this group. This is a conversation that you are seeing. There's clear interest in this topic. And there's a lot of interest, the way you are teaching is creating a lot of questions and a lot of drive. And so I wanted to take this opportunity to point out why Praktio, and Michael and his team was nice enough to create this slide to give you some of that answer. But this, one of the things we're trying to do with the Contract Teardown Show, again, mirrors this, where we're like, we know you all are going to be tempted to copy paste, but we need you to think while you're doing it. Let's model that behavior. Michael's doing the same thing with Praktio to show you, here is an example, go through the practice and think about it. That's kind of my sense of the value of what you guys are doing. Michael, tell us all more about Praktio and how you teach.
Awesome. Thanks, Mike. Yeah, exactly. So our view is you learn best through doing, and it's not just our view, it's backed up by the science. And so our platform allows for folks to practice doing practical exercises with real world examples, and you get immediate feedback on everything that you do. And you take the lesson, you apply it to the next one, you apply it to real life, right? So that's our approach. Generally, our online learning is practical, it is interactive, and it is on demand. So it's a chance to get immediate feedback through interactive exercises, but also on your own time. You can log in and spend 5 minutes in there. It automatically saves your progress, all that good stuff. It's built for busy folks to work through that kind of experiential learning. But, we know you're busy. We know a client calls, this stuff is great and riveting, but maybe you get bored and you want to turn your attention to something else. All good. It'll save your progress whenever you jump back in. It'll pick up right where you left off. I do want to get this
selfishly,
in.
yeah, I say to all of you who are here, I want to convince Michael and his team to come back and keep teaching us, to bring more information, to help us draft better contracts faster, and to use the information that's in Law Insider, which is a massive database of contracts, sample contracts, and clauses for you to be able to learn, how do I translate this into my particular context? And so the folks at Praktio were kind enough to give us a limited time offer, and I'm going to ask you to go take it. It says to Michael and to his team that we all want to learn from them. So Michael, tell us about this offer that is, as I understand it, pretty darn exclusive to the Law Insider audience.
Yeah, we've literally just never done anything like this. We don't really give discounts, but we're doing it now. It is for a very limited time. So running through the end of this month, $100 off. Go to praktio.com/law insider. It will actually automatically apply this code, but just so you have it, the code, shockingly, is also Law Insider. And take a look at our contract fundamentals course. So this will teach indemnification provisions, limitation of liability provisions, reps and warranties, all the building block provisions you find in any kind of contract. It's going to teach you the types of things we covered today, give you a lot of exercises and an opportunity to practice applying these lessons and reinforce in a way that has been proven to actually cause folks to learn a thing or two. So would love for you to check it out. Would love feedback on today's session. I hope you all got a ton out of it. Thank you for all the questions, all the engagement. As much as I love hearing myself talk, it's always great to know that others are are paying attention and asking each other questions. So thank you all so much. Really, really appreciate it.
All right, and everyone, reach out to Michael, connect with him, and look for, I'm going to rope him into helping me complete a blog post over at linesider.com/resources, where we can deal with some more of these questions and pull those over there. So if you've got any last minute questions, jump them in there. We're going to wrangle Michael later to share that smart brain. Michael, thank you for sharing with us. Again, go to praktio.com/linesider. The domain is down in the footer there of this image. We'll also follow up, as we mentioned, with materials from this conversation. You receive that in email. We appreciate you all, and we'll see you at the next learning opportunity. This webinar brought to you by LineSider and our friends at Praktio. Thank you, Michael.
Thanks, everybody. Take care.